My name is Teresa Lewis. I'm the Director, Office of the Small and Disadvantaged Business Utilization. Today's speaker is Carl Avares, Director, Office of Recipient Integrity Coordination, Office of Grants and Acquisition Policy and Accountability here at the Department of Health and Human. Carl will be providing us training today on the basics of suspensions and debarments. And Carl, I just want to welcome you. I just want you to know how important it is to keep small businesses out of trouble. So thank you.
Absolutely. Thank you, Teresa.
All right.
So this afternoon, I'm going to speak about the basics of suspension and debarment, as Teresa said. Those words have a tendency to be scary to many people. But I'd like to start out with the fact that the acquisition workforce are the very colleagues that make my work in the Office of Recipient Integrity Coordination possible. So I'd like to go into this. We have about an hour to discuss suspension and debarment. And to do that, we're going to set up the session to address the following topics. What are suspension and debarment? I think we need to talk about the differences in our language between the acquisition workforce and those of us that work in suspension and debarment. We use some of the same terms, but we use them differently. So we'll go through those terms. What causes a suspension and debarment? The FAR 9.4 gives us a great number of authorities with which to handle suspension and debarment in an acquisition context. And finally, we're going to talk about the roles and responsibilities of all of us within suspension and debarment, specifically because our newly minted guidance on suspension and debarment, released last week, starts with the words that suspension and debarment and protecting the government's best business interests are the responsibility of everyone within public service. To meet this, to set us up, let me use the words of someone much more important than me. President Barack Obama, in March of 2009, said that as guardians of taxpayer dollars, our agencies have an ongoing responsibility to make every possible effort to do business with contractors who place a premium on performance and quality and not do business with firms who are proven bad actors. We'll get back to many of the terms in that statement as we go through this session today. Recent historical trends have taught us that we need to pay attention to the suspension and debarment issues as they play out. In October of 2011, the Department of Health and Human Services was invited to participate in a congressional hearing on suspension and debarment. And we were brought in as an example of what not to do. The consolidated appropriations and the proposed budgets that followed that, that testimony spoke volumes to our need to develop a suspension and debarment program. The Government Accountability Office did a report right before that testimony in October of 2011 that criticized a number of departments for not having the basic tenets of suspension and debarment within their programs. We are happy to report that in May of 2014, the GAO released an addendum to that report that says we have seemingly gotten it right. So let's continue to go through what does exclusion mean? We talk about it in general terms, but fundamentally, you are prohibited from participating in covered transactions whether you are suspended, debarred, proposed for debarment, or you voluntarily exclude yourself. Covered transactions, as we see them, are contracts, subcontracts, grants, loans and loan guarantees, and insurance guarantees as provided by the government. So it's a broad swath of our work in government is covered if an individual or an entity is debarred, suspended, or proposed for debarment. The conundrum as I see it today, I'm going to use a pair of words that we don't have a definition for. The FAR uses the words extensively. The President used the words, and I will continue to use them throughout this session. And those words are present responsibility. It is the responsibility of every contracting officer to determine that a contractor is responsible prior to award of a contract. We will know it when we see it, but we need to use the term as does a person or an entity have integrity? Do they have business ethics? Are they capable of taking the funding that they are offered and produce the results for which they are responsible? That is generally what present responsibility is, and we will continue to use that term throughout the session right away. Suspension and debarments are an administrative action taken to keep a company or individual that has been determined not to be presently responsible from receiving future federal contracts, grants, or other assistance. Again, present responsibility is the key, and these are administrative actions to preclude future contracts. They are a significant tool in the government's toolbox, and each of these suspensions and debarments have government-wide effect unless they are established in a way to not be applicable to all government programs. Suspension offers a quick response when necessary to protect the government's best interests. The business interests of the government are key in this. Some people have taken such heinous action that we need to move quickly to remove them from consideration for future contracts and grants. And suspension is the tool that we use to do that. Both suspension and debarment protect government funding. Debarments can be fact-based or conviction-based, and we'll discuss what those entail and the strength of the decision process behind each of those. One of the most important lessons that needs to be learned about suspension and debarment, while they're scary words, is that they are to be protective of the government's business interests, not to be punitive. We are not glomming on to a court's conviction of a company or an individual and making it worse by suspending them for a period of time. We are using these tools to protect the government's interest in ensuring that we only do business with those companies and individuals that are presently responsible. We need to, in this process, consider the seriousness of the offense that was problematic in the contract, where we were blocking getting the results we needed, or we were misspending funding or submitting false claims. The Interagency Suspension and Debarment Committee chairman said recently that debarment is a discretionary decision by the government as a consumer of goods and services, which serves the purpose of protection, not punishment. It serves best to head off the participation of problem actors in federal funded activities rather than to remediate misconduct after occurrence of such misconduct. So we're trying to keep those people who have had problems from getting their next government contract. I've used the terms a lot already to this point, suspension and debarment. So let's talk for a second about the differences in those two things. A suspension is an action to disqualify an entity temporarily from government contracts, grants, or other covered transactions. A contractor that is disqualified temporarily is said to be suspended. Suspension may be imposed without prior notification to the company or the individual, which allows us for a quick response. On the other hand, a debarment is an action taken to exclude an entity for a specified period of time. The standard period of time in the FAR is defined to be 3 years. Mitigating or aggravating factors, if this was really bad or they tried to fix the problem and they let us know about it in advance, we would consider changing that specified period of time. A contractor who is excluded for a period of time is said to be debarred. And debarment requires written notice and an opportunity to respond with information and argument about our decision to debar. So I hope that has made the terms we're using a little more clear. The FAR 9.4 is very clear on potential causes for action, both for suspension and debarment, and it uses the same list for those actions. A cause for action can come from fraud in connection with a public contract, a violation of antitrust laws, theft, bribery, tax evasion, falsification of records, and all those indicators of a problem with business ethics. Unfair trade practices are a cause for action. Unpaid federal taxes in excess of $3,000 puts you at risk to being suspended or debarred. A serious violation of the terms of a government contract or subcontract, be that a lack of performance or a false claim or bad invoicing under a contract. Misrepresentations of the Made in America certifications that are part of every contract can also place you at risk of suspension and debarment. Violations of the Drug-Free Workplace Act also does that. Then there's a catch-all that offenses that indicate a lack of integrity or honesty will place you in the crosshairs of the department's suspension and debarment apparatus. And there are other various reasons listed in the FAR 9.4 that would cause you to be an entity or individual to be debarred. What does that mean once we achieve a suspension and debarment? It means a contractor will not be considered for future awards, be that an individual or be that a company, or as we call it, an entity. The contractor, however, may complete work on existing contracts unless the agency determines that there is other reason to terminate that action. The contractor is not eligible for any new work which entails extensions, additional funding, or extensions of time or money, and extensions of work on existing contracts. We can also not offer them to exercise an option on that contract because they cannot receive additional work. However, if the head of an agency determines that there is a compelling need, that this contractor is the sole source for something that the government needs, in consultation with the suspension and debarment official, that head of agency can provide a compelling need justification, and work can continue with a debarred or suspended contractor. The FAR stipulates action to be taken to refer that contract to the SDO, the suspension and debarment official, if the cause for actions are observed by the contracting officer, by the Corps, or if the programmatic personnel find that there is a problem with performance or invoicing. Where are those S&D tools that can help you determine what the next action is on a contract which we're seeing a cause for debarment or suspension? First of all, FAR 9.407-3 provides you the procedures for suspension, which also includes the list for causes. FAR 9.406-3 provides those same procedures for debarment. Not germane to this audience, but 2 CFR 180, subpart F, provides the general principles relating to suspension and debarment actions on grants and loans. Also, we have provided in recent weeks the HHS discretionary suspension and debarment program guidance to help contracting officers, corps, and program personnel, when they see a cause for debarment or suspension, to go through the process in a way that will get their concerns voiced to the suspension and debarment official. Let's go into some of that detail. HHS has a unique policy construct and program guidance because of a series of things. Our portfolio is huge. We within suspension and within HHS recognize that we are third in the government in terms of contracting, coming in at about $20 billion annually. Our grants portfolio dwarfs even that. As the largest provider of grants in the federal government, we spend about $340 to $350 billion annually on grants. Our Office of Inspector General also excludes a large number of individuals and entities on their healthcare exclusions authority under the Social Security Act. And they do about 300 of those per month, totaling between 2,500 and 3,000 of them each year. Our Office of Research Integrity further takes our authorities on suspension and debarment to address issues of research misconduct within our very large organization, be that at NIH, the Centers for Disease Control, and the like. So ORI does research misconduct actions that are then flowed through the suspension and debarment official. The Office of Inspector General does healthcare exclusions, also sent through the suspension and debarment official. And we, in the Office of Recipient Integrity Coordination, take referrals from our operating divisions and from the IG, and we forward those through the suspension and debarment official with our recommendations for action. Those of you that have come to this training, most of which are in the contracting officer representative and contracting officer realms, have certain roles within this process, and I'd just like to put those on the table. We depend on you to uncover bad acts during market research and through contract performance. We need you to find those egregious performance problems that are repetitive and consistent in your contracts. We need to know when there are significant or repeated non-compliance issues with the terms and conditions of a contract. We need to understand when you find ethics and legal violations, and we, the Office of Inspector General, the Office of General Counsel, and the Department of Justice will provide you with information when we see those ethics violations or convictions for such violations. It is incumbent on the contracting officer, with the assistance of the Corps, to determine present responsibility. To help in that, the System for Award Management, or SAM, is available to contracting officers to check. And that's not only at award, it is at proposal, it is award, and it is at option stages for each contract. The contracting officer representative, or Corps, observes the performance and invoicing of that contract and looks for those signs of impropriety. And finally, the Corps applies the standard procedures described in FAR 9.1 in conjunction with the CO to make sure that the contractor in question, prior to award, prior to option, is and remains presently responsible. We have a series of varied stakeholders within the suspension and debarment process in HHS. And I will speak to those because those are the ones that we use. So the suspension and debarment official is our Deputy Assistant Secretary for Grants and Acquisition Policy and Accountability. She's currently the DAS for OGAPA and the suspension and debarment official as placed in that role by the Assistant Secretary for Financial Resources. We have created within OGAPA the Office of Recipient Integrity Coordination, which I have the opportunity to work in. We are a small staff that makes recommendations to the SDO, Nancy Gunderson, on cases as they're presented to us by the operating divisions and by our other stakeholders. The referring entities, as we see them, are the Office of Inspector General as our law enforcement arm, the Office of Research Integrity on those research misconduct questions, the operating divisions and staff divisions across HHS, including but not exclusively the responsibility of the heads of contracting activities and the chief grants management officials. The other stakeholders that are very important to us are those of you that are on this video. The cores and programmatic personnel are in a uniquely close situation to contract activities and therefore have a unique role in bringing bad behavior and misconduct to the forefront in our S&D activities. We will often receive a referral from one of the referring entities, and we will go to the programmatic personnel and the cores to find out their perspectives on these issues. So what are the procedures that are at play? You've heard me use the word referral or refer. A referral is the report that provides to the suspension and debarment official our concerns about misconduct and the future conduct of a contractor, individual, or entity. My office, ORIC, checks the System for Award Management, or SAM, and coordinates lead agency responsibility within the Interagency Suspension and Debarment Committee. Therefore, we say, we have a contract, we've seen a cause for suspension and debarment, and we are going to take responsibility. But it offers the opportunity to other agencies and departments across the government to say they also want to be part of this action, or they would prefer to take leadership on the action based on their status as the harmed party. If a small, excuse me just a second. If a small business is involved in this process, we would work with Teresa Lewis's shop, the Office of Small Disadvantaged Business Utilization here within HHS, and they will refer those to the Small Business Administration to determine next steps on how to recommend action on the small business to the SDO, Nancy Gunderson. We would ask at that time, as the referral is being done, that a referral of information be completed for submission to the SDO through ORIC. This document describes the action sought, provides the name of the respondent or respondents. We will see many of these that include an individual and company, or a company and a series of individuals who were considered to be bad actors on that contract action. It will provide a factual narrative to support the action sought with documentation of that narrative. If there are court documents, we would get those. If there are audit documents, we would also get those as part of the factual narrative. It would determine if a suspension and debarment was considered to provide a quick response to the bad acts. It would recommend a period of any debarment to the SDO based on mitigating factors, acts that the person or entity took that made the situation worse, how bad it was, how large the amount of funding involved was, or, those are the aggravating factors. The mitigating factors are those things that they did to make it kind of right. Did they come to the government and say, we've discovered this within our workforce? We discovered a failure to perform. We discovered an incorrect or inappropriate invoice along the way. So they will tell us, and they will tell you, and we would hope that the referral would include those mitigating and aggravating factors as a determination on what the best period of debarment would be. And it would also reference all the coordination and collaboration that was done with the other stakeholders in suspension and debarment as you were developing this case and the causes for debarment. Procedurally, that would be followed by a decision from the suspension and debarment official, or SDO. ORIC will submit your referral to the SDO with our recommendation on how she should proceed. The SDO will then make a decision on the initial proposal for debarment, the initial recommendation for suspension, or the final decision on debarment. It is a discretionary decision. She has broad discretion as defined in the FAR and 2 CFR on whether to debar. And she does that based on the need to protect the government business interest at that time from that respondent. We try to keep these resolutions as informal as possible. If a respondent would like to come in and discuss the proposed debarment of their company or themselves, they are welcome to do that. Similarly, if a contracting officer wants to discuss things they've seen on a contract and not to take it any further, we will also have those informal discussions with ORIC. Under the FAR, the point at which a person is excluded is at that notice of proposed debarment. A decision is made to propose for debarment, and under the FAR, that entity or that respondent is placed within the system for award management as excluded from that day. If a decision is made subsequent to that not to permanently debar for a period of time, the respondent will be removed from debarment. The respondent, from the point of a proposed debarment, has 30 days to submit information or argument on the proposed action. The suspension and debarment official will use this information in addition to the referral at the time of decision, both for the proposed debarment and for the final debarment or for a suspension. The SDO will provide within 30 business days a final determination on the action after receiving the information and argument from the respondent. So the decision will be made by the suspension and debarment based on your referral. The considerations that our suspension and debarment program here at HHS have prioritized. We believe that HHS must be fair and apply sound judgment in each responsibility determination and award decision. We are convinced that remain with the CO even when asked by respondents to provide them with a determination that they have done things to become presently responsible since the bad acts or the misconduct took place. We will always, within our organization, leave that determination to the contracting officer at the time of award. Relevant information must be referred to the SDO for appropriate action. We have seen within HHS and other departments a determination on the part of the contracting workforce that it isn't bad enough to really need a suspension or a debarment. So the acts are dealt with within the operating division and not referred. The exclusive authority to make that determination remains with the SDO. So if there was if one of the causes for debarment or suspension was tripped, in your investigation of a contractor, it should be referred to the SDO to make a determination. Even if your recommendation is that a suspension or debarment is unnecessary at the time, the decision needs to be made by the SDO. Repeated determinations of non-responsibility are problematic within a suspension and debarment and a regulatory construct, because they could create what is termed a de facto debarment, denying a vendor due process. So we say repeatedly that, oh, they're not responsible in awarding a contract, and they are not getting the benefits of a recommendation to debar based on that lack of present responsibility. Therefore, we would ask that no action be taken based on a conviction that or a court case that is underway, or a very public, for example, an FBI raid of a company. So we want to avoid de facto debarments in a substantive way. And if you find that you're determining a company to be non-responsible in a repeated way, we would recommend that you speak with somebody in ORIC or refer to the SDO, the name of that contractor. FAPUS makes performance data on vendors publicly available and may drive a perception of a need to act. If you're seeing, not only are we having trouble getting the deliverables from a contract on our contract, but other agencies and departments may be having the same problem. This may be an indication to you that a cause for debarment or suspension exists. We'd like to be more positive then and talk about some best practices in suspension and debarment that we have seen over time. We would recommend that SAM be checked for exclusions immediately prior to award of any contract or any grant. This also needs to be done when proposals come in. The respondent is notified at the time of a proposed debarment or a suspension that their exclusion will include not being considered for a future contract. Therefore, a proposal from an excluded party should not be considered as having been submitted for the consideration of an evaluation panel. So checking SAM regularly through the procurement process is key to doing this in a positive way, but should be done immediately prior to award to ensure that something hasn't changed in the process. Be sure as you're doing this to check the name of the current company and the names of the company's principals. Principals are generally described as those people in the chief suite: the chief operating officer, the chief executive officer, the chief financial officer, the chief accountability officer. All of those are considered to be key personnel or principals, and we need to make sure that we are not doing business with them by doing business with a company of which they are part. If you have concerns about the contractor not being presently responsible, we would recommend you refer the issue to the HHS suspension and debarment official after discussions with ORIC, the IG, or general counsel. We would ask that you exercise that very important sound business judgment, which you've been empowered with in looking at these contractors and grants. We would ask that you be willing to suspend or debar contractors as appropriate, and do not de facto debar them by just making a determinant of a lack of present responsibility without providing them the due process of determining that and seeking a decision from the suspension and debarment official. Again, we have some resources to help you out with those processes. Because we are aware of these things doesn't mean that you will always have a facility with them. So we would recommend, again, the 2014 discretionary suspension and debarment program guidance for you to consider. The VAO webinar on suspension and debarment in federal contracting, which was done by the General Services Administration, is a key tool in determining where you are seeing a cause for debarment or suspension. FAR 9.4 provides debarment, suspension, and ineligibility regulatory language upon which you can depend. And finally, the Interagency Suspension and Debarment Committee will offer to discuss all issues that you're seeing on a specific contract in a way that will not require you to divulge any information that you're uncomfortable with, any information that would be inappropriate under the contract, but would give you the benefits of a government-wide set of experts that can help you get through this process. Finally, if you need anything at this point, you are welcome to give me a call at any of the numbers or send me an email. Discomfort is grounds to begin this conversation. If you're seeing repeated problematic invoices, if you're seeing a failure to provide a needed deliverable, you are welcome to give us a call and ask us, does this rise to the level of those causes of suspension that are in the FAR? I'd like to offer at this point the opportunity to take your questions to see if I can set your minds at ease on any of these problematic words of suspension and debarment that we've been discussing today, and to prove that I believe that you are our primary colleagues in getting this work done, which is very important to the business interests of the federal government.
Well, Carl, thank you very much. I truly appreciate this informative presentation on suspension and debarment. So let's see if we have any questions. The one on the left.
I keep hitting the wrong one. I apologize.
That one, and then hit the refresh.
Refresh.
Okay. Well, while we're waiting to see if there are any questions, okay, very good. The question is this presentation being taped? The answer is absolutely yes. So next question. Let's see. Please explain the difference between a formal suspension debarment versus a CO deciding that a contractor is not a responsible contractor for a particular procurement. Isn't a non-responsibility determination a de facto suspension for that procurement?
The answer to that is a bit complicated. My understanding is that a single non-responsibility determination is not a de facto debarment or suspension. It is when those become repeated. If the same contractor is coming in for the same types of contract and we are regularly and repeatedly determining them to be non-responsible, and in our debrief of that contractor on that non-responsibility determination, we are not getting through to them that this is not in their wheelhouse, it could be viewed as a de facto debarment. Therefore, a single is not a problem. It is when those become repeated and when we have debriefed the contractor and they have not heard our message that we need to begin to determine, are they non-responsible for more than just that procurement?
But Carl, also another issue that I want the contracting officers to keep in mind, that if a small business is determined to be non-responsible, that they should request a certificate of competency by the Small Business Administration. So, next question. What due process is afforded contractors before they are suspended?
Due process to contractors Again, I apologize if this is overly complicated. I'm trying to keep it simple. We depend in this process, and I referenced it in the factual narrative discussion, we depend on publicly available court documentation and audit findings to determine where bad acts have taken place. Therefore, we are extending the due process of a court case or an audit to that contractor. We are also required by the FAR to provide a notice and comment period to that contractor in proposing them for debarment. While a suspension can be put in place immediately with the notice, we also offer them an opportunity to come in and discuss it with us or to submit information as to why they should not be suspended at that time. So we have given them a series of times during which we are using publicly available documentation to, and we are notifying them of our potential actions with comment periods built in to ensure that they have received full notice and full opportunity to make this decision the best one for them and for the government.
Well, Carl, is the process different for a large, and how we treat a large business versus how we treat a small business?
I don't believe that there is a huge amount of difference.
Okay.
The Small Business Administration would be notified through your staff if a small business is determined to be proposed for debarment.
Okay.
So we would take an additional step for a small business, but it is not a difference in treatment.
Okay.
We are just having the discussions about the implications of there being a small business and their ability to participate wholly in the suspension and debarment process.
Okay, thank you. That's very helpful. Next question. Can a contractor be disbarred for using illegal aliens on a government job or a government contract?
The violation of the laws of the nation are the exact thing that we are using to gauge business integrity and business ethics, so that using illegal aliens is a violation of our immigration laws and is therefore a standing ground for debarment and or suspension.
Okay. And who at HHS coordinates debarment actions?
That would be me.
Okay.
I have a small staff of 3 other analysts with expertise in the various areas of suspension and debarment. I have a grants expert, I have an administrative expert, and I have a contracting expert on staff. Phone calls are fine as the mechanism to get to us. We can have these discussions very informally with a limited set of information so that you are comfortable coming to us, and we will not move to discuss these issues with the suspension and debarment official until a referral comes in. And we had the discussion during the training about what a referral is. And so we will try to keep these as informal as possible. So use my contact information, which is in the presentation. Give me a call, write me an email, tell me what you need from us, and we will assign somebody to work you through this process. And that person will often walk you through, if a referral is submitted, all the way to decision on final debarment.
Okay, very good. So let's refresh the questions to see if we got any additional ones. Okay. So, if a contractor does not pay employees and it is reported to the contracting officer, is the cause for suspension or debarment?
I would need to defer that to counsel to determine just where if there's a violation of law in this. we cannot presume that a failure to pay is a violation of law. There may be other things at work. So that we would hope that the contracting officer would confer with counsel to get to a point where we could determine, is there a violation of law? Is there a lack of business integrity in this action?
Okay, very good. Is there a certain section on SAM that depicts the debarment?
Yes. New to SAM is you can do an advanced search for debarment information in SAM. If you go to the, I'm doing this off the top of my head, if you go to the search records tab at the top of the screen, you will have the opportunity to select the advanced search for exclusions. Exclusions are also reflected in SAM throughout the system with a purple box to the left, and they are shown as exclusions. So you will see in some cases the contractor's registration in the registration system, and you will see the exclusion of that contractor also, and they will be separate records. You will sometimes see a number of exclusion records for the same respondent, and that has to do with shared authorities in suspension and debarment, where, for example, our healthcare exclusions, which we discussed, that come out of our Office of Inspector General, will be seconded by an Office of Personnel Management exclusion, so that those people are no longer eligible to participate as providers under the federal employee health benefits programs. So there are shared authorities, and you will see multiples in there. But the advanced search capability is new to SAM and will let you drill down into all the exclusion data that you could need. For those of you within HHS, we also have an online searchable database in the Office of the Inspector General. So if you go to oig.hhs.gov, you can find a online searchable database with additional information on these respondents for our healthcare exclusions.
Okay.
And there are about 50,000 of those in SAM today.
All right. So Carl, how long does a contractor have to dispute the suspension or debarment?
So the word dispute is stronger than we are comfortable with. At the proposal for debarment, there is a 30-day information and argument period established from receipt of that letter. So we determine when the letter is received by the respondent, and they have 30 days in which to send to us directly from themselves, send to us from counsel, or request an opportunity to meet with the suspension and debarment official to discuss the case against them. We also offer that less formally to those people we suspend. In their notification of suspension, they will be notified that they are welcome to send us a set of information and an argument as to whether they think we got this wrong.
Okay.
And the suspension and debarment official will take all of that information, that which we have compiled within the government, and that which the respondent sends to us, and she will use all of that in making her final determination of suspension or debarment.
Okay, very good. If a vendor is unfortunate and makes the press for a significant problem, how can a contracting officers know that there have been repeated determinations leading to a de facto debarment? Is there a clearinghouse somewhere?
To my read, there is not a clearinghouse. We had this happen very recently within HHS, and I'll just give you the general terms of that situation and how we proceeded. A company was raided very publicly for a false claims problem that they were experiencing that had been investigated by the FBI. The FBI, the video of this raid was put on the internet. When one of our contracting officers Googled, as part of their due diligence to determine present responsibility, this company, they came across this video. It gave them pause.
Yes.
As it would any of us.
Yes.
And they came to us and they asked the question very bluntly, can I give this contract, can I award this contract to this contractor? Our answer was very clear. Our suspension and debarment official concurred with our answer. The answer is absolutely. Until we have gone through such process as we have determined them to be not presently responsible and to have been convicted or indicted of those acts, we cannot presume them to be not presently responsible. However, we did do the additional work to determine who in the federal government had contracts with this contractor, and we looked in FAPUS to determine if there had been any performance challenges with that contractor on any contracts in government. We did not determine that to be the case.
Okay.
And so this contract was awarded to this contractor who had a cloud over their heads because we had not determined them to be not presently responsible. The contracting officer made that determination with the information they had, and the contract was awarded.
Okay, very good. The question has come in for us to clarify when there is a small business involved, should the contracting officer get a certificate of competency from OSDBU or from another agency? Only the U.S. Small Business Administration can issue the certificate of competency, or as they refer to it, a COC. You should coordinate with your small business specialist and they can assist you with that process. All right, next question. Are there protections for an accuser if the alleged person is their boss or in the chain of command?
That's one I've never seen.
Okay.
I have found that when performance challenges are seen, they're usually very clear. When a core or a contracting officer is uncomfortable with repeated challenges with invoicing, that their entire chain of command has a tendency to take that seriously. We have seen that the contracting officer is the person to where the rubber meets the road. Let's put it that way. If you don't feel comfortable with the support of your management as a contracting officer, and you feel it's necessary to look at causes of debarment, we are more than willing within ORIC to have a discussion. More importantly, the place to take this is to the Office of Inspector General's tip line. Within HHS, and for those of you that are from HHS, there's a web presence. There is an email address within the Office of the Inspector General, and it's very prominently posted on their website, with which to report inappropriate behavior, inappropriate conduct on a contract. It is an attempt to preclude fraud, waste, and abuse within the department, and they will pick up this based on what they see.
Okay.
So there are various sources to get this to the right people that doesn't entail bludgeoning it through your chain of command if you're not feeling the support.
Okay, very good, very good. So can you refresh to see if we have any additional questions? Okay. What is the recent history, for example, 3 years, of the number of suspensions or debarments which have been imposed by the Department of Health and Human Services?
I believe that this is something I'll beam while I'm telling you, because I'm very proud of the work of my folks. In 2011, in fiscal 2011, we saw 6 debarments within the department and 2 administrative agreements in lieu of a debarment. In 2012, as we were developing our newly robust program, we saw one action within the suspension and debarment process. In 2013, we're very, very proud to report that we saw 47 actions within the department in fiscal 2013. So you are seeing, we are referrals from an expanded audience of and universe of entities. We have seen our first in 2013 Optiv or operating division provided referrals. Our Office of Inspector General is seeing more clarity in applying their audit findings to suspension and debarment referrals. So we're seeing this come in from a wide variety of places. We have taken over a number of cases from other federal departments because we are big enough and we have the robust policies and procedures in place to get them done. We also have provided to another department one of our cases where we had a conflict of interest within the system. And so more flexibility, which is allowing for more cases to be finalized in the process. And
Okay.
we envision that continuing in 2014 and beyond.
Very good. Let me congratulate you and your team on
Thank
your
you.
significant efforts and taking the lead within the federal government.
Thank you very much.
Absolutely. So let's see if we have any additional questions.
That's
That's it. I think we've covered them all.
Teresa, I see within the questions a series of requests that the charts and the slides I used
PowerPoints, yes.
were subtly different from the ones that were sent out. Could I ask that we send out a final deck?
Absolutely.
And I
So-
apologize to everyone that was on if that
Absolutely.
caused any frustration.
Absolutely. So what will happen is we will upload this video into FATAS as well as the PowerPoint presentation. So my team will get together with your team to get the current and most accurate PowerPoint presentation, and that information will be made available in FATAS.
Perfect.
Okay? So Carl, let me just thank you very much. I appreciate you coming in today and training everybody on suspension and debarment. It was very helpful, very informative, and we will archive it again in FATAS. And again, I just thank you all so much, and just congratulations again on the success that you're making with the Department of Health and Human Services suspension and debarment program.
And I couldn't do that without the contracting officers, corps, and programmatic personnel that provide us with our source.
Okay, very good.
Thank you.
So thank you all for joining us today, and we will see you next time.